Without further ado, please let me introduce our speakers and community leaders for today. They are joining us from the neighbor island of Maui. Our first presenter is Dr. Lance Collins, who is an attorney in private practice on the island of Maui. He has a PhD in political science for the University of Hawaii at Manoa. He practices in agency proceedings, civil litigation, and civil appeals. He volunteers as the coordinator of the Affiliate Pro Bono program. He is co-editor of the books Tourism Impacts West Maui, Social Change in West Maui, and Civil Society in West Maui. He serves as a trustee for the International Philippine Studies Association and a governor for the Hawaii Academy of Recording Arts. Without further ado, I'm going to turn it over to Lance. Thank you so much, Lance, for being with us today.
Aloha and thank you. I'm going to try to share my open office PowerPoint equivalent. Okay, so I'm going to be talking about water and law in Maui using the framework of the sort of debates and contentions and the different perspectives and points of view, and hopefully touch a bit on history. So the first point I wanted to sort of frame water and the law is why water law. And I'm very sorry, I don't mean to read the slides, and this may be the only one where I'm going to be mostly doing that. But so water is an important public good that satisfies numerous human needs. And while it is generally plentiful, water of the right quality in the right place at the right time is not so plentiful. And so water law attempts to address the competition over uses in an orderly manner. So that's in a broad sense, that's what water law is supposed to be about. There are many ways in which the law can manage the various competing uses for water. I'm going to focus on, just for a moment, for comparison and to help create a reference point, US water law systems, and then I'll talk specifically about a Hawaiian water law system, which is a little bit different than the US water law systems. So the first type of US water law system is called the Riparian Rights system. And this picture is actually, I believe it's from somewhere in Europe, possibly England, which is where the Riparian Rights system came from. And the idea behind riparian rights is that basically landowners that border waterways have a right to the reasonable use of water bordering their land. And so the entire use of water comes from basically the riparian rights of bordering landowners to streams and waterways. A second water law system developed in the US, primarily in Western states, called the prior appropriation system. And that was founded on the concept of the first person to use the water had the first right to it, regardless of how far away from the actual waterway or water source. And I put a quote, and I see I missed the other quote here, but first in time, first in right is sort of in quotes because it's not actually the first in time, because basically the American Indians who lived in all of these places and were the first people to use the waters, their rights weren't ever incorporated into the prior appropriation system. So I want to just sort of put this in quotes or an asterisk, because the prior appropriation system under US water law actually is founded on erasing the first people who are using the water, and was the first basically white Americans or Western Europeans to use the water, got to be considered the first, and anybody before that wasn't counted. Okay, and then there's hybrid systems that, and I think most US water systems are somewhat of a hybrid now between riparian rights and the later adopted prior appropriation. All of this, the areas that used to use prior appropriation have incorporated some kind of riparian rights doctrine and vice versa. And then there are three other systems that fall within the US water law universe, and that's the Louisiana system, which is based on the Civil Code. the Pueblo system, which has to do with Indian water law, primarily in New Mexico, but I think also in Arizona, Colorado, and I don't think it extends to Utah. But it's most of the litigation in Pueblo water law is in New Mexico. And then there's the Hawaiian water law system. Okay, and so the Hawaiian water law system, in a basic sense, it was founded on the rights to sufficient water for primarily Kolao farming, but actually any subsistence farming, but primarily Kolao farming, because that was primarily what was farmed for subsistence purposes, that were pertinent to the land. And the konohiki, or the basically supervising agent of the chiefs, could allocate surplus water after basic needs of the appurtenant right holders were met. And at the time of the Mahele in 1848, surplus water was reserved to the people for their common good. And so that, as long as that's part of the Hawaiian legal system, that will forever not allow water to be strictly a riparian or prior appropriation. It could never be a riparian or prior appropriation system like the American systems, because surplus water is reserved to the people for their common good. And that's not how the riparian system or the prior appropriation system works. So I've shown here just a basic schematic of the Ahupua, which is a type of land division in traditional Hawaiian land concepts. So islands were divided into districts, and districts were then divided into Ahupua. And then, of course, Ahupua, there were smaller, well, there's actually a few other things called kalanas and stuff, but the Ahupua sort of additionally could be reduced into smaller portions of land like Ili and Lele. But the Ahupua is sort of considered for water purposes to be the basic unit. I know that there's some people have said, well, the Ahupua is coextensive with watersheds, and that's not true. There's been some scholarship by Kamana Beamer and Lawrence Gorsuch and others who have demonstrated that that's not true. In many instances, they are coextensive, and in other instances, they're not. So in any event, this is supposed to represent a typical land division. And the idea is that as water flows from the mountain to the ocean, you have both the surface and the groundwater. And this is supposed to sort of demonstrate that as water makes its way to the ocean, there's sort of this natural way in which water moves, and that the Hawaiian water system tried to accommodate and work with that, as opposed to working against it and modifying it. Okay. So there were some changes in the traditional Hawaiian water system, water law system. The plantation economy was founded on major diversions of water away from Ahupua. And as I get to the Maui water battles, this is very important. So Hawaiians did divert surplus waters from the streams. There's actually quite extensive irrigation systems. Typically, the water remained within the Ahupua or would go to an adjoining Ahupua. But after the Reciprocity Treaty, there was a massive influx of American capital into Hawaii in the 1870s. And when that happened, suddenly the money became available to foreigners who were developing their own sugar plantations, that they had purchased lands on marginal lands without the necessary water to grow sugarcane. And so they used the capital to develop extensive water diversion systems to basically irrigate these lands that they had purchased that were leasing, that were not suitable for non-irrigated cane production. And so the 1870s is the beginning of these major diversions of water away from the Ahupua. And as after the overthrow and basically as the plantation system became the controlling political factor in Hawaii, that included some effect on the court system, which determined what Hawaiian water law was. And it was kind of, the courts never could really put their finger on what they were trying to do, in part because the Hawaiian water law system does not easily fit into prior appropriation or riparian. And so courts during the territorial period had a very difficult time sort of wresting water control from the previous system. And in the 1970s, in McBride versus Robinson, the Hawaii Supreme Court reaffirmed that the Hawaiian water law system was not an American water legal system, and that surplus waters were part of the public trust, and that the state, as a successor to the monarchy, had to comply with public trust principles in the use and management of water. So as that happened, there were some provisions that were added to the Hawaii state constitution that enshrined those legal points, and including requiring there to be a water code. And it took almost 10 years for the state legislature to pass a water code, primarily because of pushback from the what was now the declining plantation economy. But as we find out, as the plantations declined, water diversions ended up becoming very useful for other forms of capital investment, such as tourism. So we'll get to that in just a moment. Okay, so the public trust doctrine, which is very important, it does appear in American law, it does appear in other legal systems, but how it's applied in the context of water in Hawaii is that it applies to all water resources. That means the state has a duty to protect water resources, and it has a duty to promote reasonable and beneficial use. And the court has repeatedly reaffirmed that private commercial gain use of water is not a public trust purpose. So that's something, if people ask, what is the public trust doctrine? What's its purpose? That's its purpose. So the water code sort of prioritizes different rights in the use of water. And here's a couple of other things to know about the water code. So appurtenant rights are, as I described earlier, are basically the rights of taro farmers and others to use water that comes through the stream. There are other uses of water by Native Hawaiians, either as tenants in the Ahupua or traditional customary practices that are recognized by the water code and prioritized. Then there are riparian rights. And so the riparian rights are, so what happened during the territorial period is that courts would determine that a certain plantation that had purchased land somewhere had a riparian right, even though that isn't totally consistent with Hawaiian water law. So to the extent that a court had made a final determination that somebody had some right to use water, nearby water, even though that doesn't really fit within the framework of Hawaiian water law, our water code recognizes that, so for purposes of the state not getting sued, that those rights continue. There's some correlative rights, which is a relatively minor concept. One of the biggest ways that the state manages water is they will designate watersheds as a water management area, and that can either be groundwater, which is the water that flows under the ground, or it can be surface water, which is water that flows above ground. They also regulate and manage water through in-stream flow standards, and I'll mention that in the context of Maui struggles. And when something, it has been designated as a water management area, and actually, even if it's not, the permitting and reporting of stream diversion works is required. So no one is allowed to divert water, even from unmanaged streams, without getting a permit from the state. And then another important concept is sustainable yields, and that's particularly important for the groundwater that is taken from central Maui. Okay, so this is from the Honolulu Board of Water Supply. This is the so-called hydrologic cycle. And it just basically demonstrates that water falls as rainfall, partly based on wind and other meteorological factors. And then sometimes actually water gets absorbed into the ground through plants, just basically taking in the moisture from air. That water percolates down and basically stores above salt water that's below the island in a freshwater lens. That's also gets perched because of various geological features. And so actually high up on mountains, there is basically stored water. And if you're old enough, you may remember, I'm not old enough, but I have seen pictures of basically perennial waterfalls on Oahu, in the Kolao, on Maui, and different places. Every island had them. But as water is being taken from the groundwater and through springs and stuff, those sort of high, sort of magically appearing water sources have mostly all disappeared, and you only see those kinds of waterfalls when there's a heavy rain or something like that, and it's just water flowing directly down the mountain. Anyways, so this is the basic concept of the hydrologic cycle and what it looks like for islands. Okay, so let's talk about Maui. So these are the hydrologic units that the state recognizes for Maui. So I'm going to be talking about the Kolao, the Wailuku, and the Lahaina hydrologic unit districts. That's the purple, orange, and green. I will also be mentioning briefly about central Maui and Hana and Kahiki Nui, but most of the water that's used on Maui comes from those three districts, hydrological districts, and all of the disputes have come through those. Okay, so the first is the Kolao hydrologic units. This is a map of the East Maui diversion system. So to the right is Kainai, and to the left is Kahului. I think maybe you can see Kahului Airport. I don't know if it's too small for folks, but so what happens is there the windward side of the island is to the right, and the left side on this map is drier. And so what the plantations did was they diverted water from the wet part of the island through all of the streams that pass, basically on this map, it would be from the bottom of the map towards the ocean at the top of the map, and have diversion systems and ditches that run from basically Kainai all the way to central Maui. And if you remember in the previous slide here, the central Maui has 26 million gallons of water per day for this whole area. So there's no water, but the Kolao district has 604 million gallons of water a day. That's not correct. I'm sorry. That's the Commission on Water Resource Management. It's like 400, somewhere between 400 and 600 million. Sorry, I don't know why it's not there. And Hana also has a huge daily millions of gallons a day of water flow in the streams. And so the diversions take the water from the Kolao streams and divert it over to Paia and central Maui and South Maui. Well, that's what it used to do. It doesn't take things to South Maui anymore. But that's, as you can see, I mean, it does really actually go upslope of what's present day Kihei. And so for 100 years, these water diversions fed sugarcane and pineapple for a huge portion of central Maui. Well, it turned out that after the water code was adopted, everybody suddenly realized, wait a second, Alexander and Baldwin who owns the diversions, never got permission from the state to be using basically what's state water. 150 years ago, when they built the Hamakua ditch, which was the first ditch, and actually it was from Haiku to Makua or Haliʻimaile. It wasn't all the way from Keanai to Kihei, but they did get permission from the kingdom. So anyways, long story short was people realized, yeah, like they don't have permission, we need to challenge this. And so East Maui taro farmers, and here's a few of them from Keanai, from Honopo, and Went is not from Waikamoi. Maybe it's Honomano. I can't remember which valley he's in. But anyways, so all of the valleys from basically the easternmost intake to Waikamoi challenged it in many different ways. And through multiple lawsuits that went up to the Hawaii Supreme Court, and I mean, a bunch of lawsuits, a bunch of agency proceedings, the diversions have been lessened. There's still challenges to it. The state they do not have a lease to take the waters. They've been given annual revocable permits. Those have been challenged because annual revocable permits are not supposed to be used in place of a lease. Anyway, so the East Maui taro farmers have been challenging that. They have gotten a couple of successes. There's a major case that's been pending before the Hawaii Supreme Court for the last year and a half. But that's the story of East Maui. And some streams have had full stream flow restored, and residents of those areas have been able to take advantage of that and truly replant out their valleys in kalo cultivation and other crops. Okay, now this is the Nevaya Eha diversion system. So this is Waihe'e, Wai'ehu, Wailuku, and Waikapu. So today, I think most people associate these areas with urban living, but this entire area used to be a huge taro cultivation area, the whole thing. But because of these diversions and the plantations using legal things in terms of controlling the land, a lot of families, taro plantations, taro farms were destroyed for lack of water. What also happened about 20 years ago is that the state designated these areas, or some of them, as water management groundwater areas, because what's not shown on this map is that most or all of the water that goes to South Maui, so all of the water that goes to all of the people who live here and all of the hotels and developments in South Maui, get their water from the aquifer under Iao Valley. So that's how you can have resort living in a desert. So the Nevaya Eha group also has challenged that. And these are the Deweys with Huio Nevaya Eha, and then Hokuau Pellegrino, my classmate, and some of their grandkids and kids and so forth. And they have, like the East Maui farmers, they have also challenged basically it's no longer a plantation. It's a water company that was a spinoff of the plantation that is sort of just holding control over all of the diversions. And they also are challenging that, and they have been relatively successful. I think they just had a settlement agreement on some of the issues there as well. And so taro cultivation has increased again, and Mauka to Makai stream flows have also increased. So there's all sorts of native flora and fauna that have reappeared in the streams since that's happened. Okay, and then the final Maui diversion system is the West Maui diversion system. So I don't want to oversimplify this, but there's basically three main water sources that feed most of the rest of West Maui, and that is water comes from the Honokohau Valley, which is here, and then there's the Kahoma Kanaha streams, and that is maybe here in this area. Might be a little bit off. Oh no, I am off. That's not Honokoi. Yeah, it's here, and then Kauaula Valley also supplies a significant amount of water, and that's basically right around here. And so in this area, what has happened is when the plantation closed in 1999, there were some land companies that basically bought up all of the land, and if you drive to Lahaina from central Maui, before you get to Lahaina town, what used to be cane fields from Olowalu to Lahaina town is basically now huge so-called gentleman estates, and all of the water for those gentleman farms comes from Kauula Stream. And similarly, in the Mauka lands above Ka'anapali, there's a similar situation with so-called gentleman farms. And all of that, the water from that comes primarily from Honokohau Valley. So the people are all here, supposedly growing coffee, or coffee's being grown on their behalf around their mansions, and all of the water comes from this valley. And Honokohau, for example, used to be a really well-known, up until the 30s, used to be a really well-known taro cultivation employee manufacturing area. So these folks, and I actually represent people in each of these pictures. We have the Kahoma folks. This is Archie Kalepa. This is Keaumoku Kapu for Kauaula Valley. And then these are the Namamo Huio, the Huio Namamo Aloha Aina Honokohau folks in Honokohau Valley. And they are presently in struggles with the Commission on Water Resource Management and other areas to get stream flow back. The Kahoma Kanaha has done it. Kauaula has it on paper, although they're still trying to enforce it. And Honokohau just got amended in-stream flow standards, and so they're still working out with the major landowner of the area about that. So this is my last slide. So there are public trust duties, there are certain priorities, but the basic principle in this, why it's taking so long for all of these issues, which everybody thought was decided 50 years ago at the 1978 CONCON, why is it still going on, is because the court also recognizes that the Water Commission has to weigh competing public and private water uses on a case-by-case basis. According to the appropriate standards, it's provided by law, whether it's a public trust purpose, a non-public trust purpose, whether it's involves somebody's particular right to use water, or if it's just the reasonable and beneficial use of water. And so because of that, that's why what should be the law isn't necessarily implemented instantaneously, because there's so many moving parts and everything has to be weighed on a case-by-case basis. So I hope that I've given some insight into water law and how it has played out in Maui. And I'm happy to answer any questions that don't require me to reveal any confidences of my clients. Please feel free to ask, and I hope I can answer.
Thank you so much, Lance. That was awesome. Very insightful and fascinating topic.